my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the 2021 Supreme Court of the United States and the Computer Fraud and Abuse Act. There were two cases that went up to the Supreme Court in 2021. Both of them touch a bit on the Computer Fraud and Abuse Act, and now they're somewhat related or connected in a very unusual way. Actually, I had done a previous video about the Computer Fraud and Abuse Act and also one on data scraping. So this particular video sort of pulls those two together and does an update. So there was a case that went in front of the Supreme Court that people were watching very closely. I was watching very closely. It was Van Buren versus the United States, and it was about a police officer that was fired for looking up the license plate number of an individual as a favor for someone else for money. The company or the police department said that his access to that data was unauthorized and he was fired, but then also he was charged under the Computer Fraud and Abuse Act because they said that they thought it was a criminal act. So the case in front of the Supreme Court, actually the 11th Circuit upheld part of that conviction, saying that yes, it was a crime. The case went to the Supreme Court recently, and they actually overturned it, saying that although the individual may have broken company rules by looking at this data, the fact that he had access to it at all meant that it wasn't a crime that was punishable under the Computer Fraud and Abuse Act. So this particular decision is going to have wide-ranging implications for employers, especially as it relates to access to data within their organization. So in theory, what this ruling is saying is, companies have capabilities, whether operational or digitally, to restrict access to individuals. So if someone is looking at something within a company and they have access to that as part of their job, that's not considered a crime. So I think a lot of companies have tried to use this particular act to bring charges against individuals within companies. A lot of times it's for like trade secret and stuff like that. But basically they're saying if the person has access to the vault, then that's not illegal, even though it may be against a company policy. So companies need to really look at that very closely. So basically that resolved that particular case. So that created like a huge precedent, especially is basically narrowing the types of things that can be considered a computer crime or punishable under this particular act. The thing that has happened is very interesting is that it has impacted another case, which is the LinkedIn HiQ data scraping case. So this is a case where this company HQ is scraping data from LinkedIn, which is publicly available, and they're using it for their own purposes. LinkedIn filed this case, or actually Microsoft, who owns LinkedIn, because they don't want HiQ to data scrape from their systems. Another part of this case earlier, I think it's 2020 or 2019, set a precedent that data scraping is not hacking. So it really can't consider data scraping hacking, so it's not criminal in that way. But the Supreme Court also pushed this data scraping case back to the 9th Circuit to sort of have a redo because of this Van Buren case. So that may have other implications. So we know right now in the Van Buren case, they're trying to narrow the scope of what is considered computer fraud and abuse, especially in the Van Buren case is about an employee of a police department. But it is going to be crazy to see how it's going to be implemented or how it's going to impact this data scraping case, because HQ isn't an employee, obviously, of LinkedIn, even though the data that they are scraping is publicly available information. Even if it's against the terms of service of LinkedIn, that may not be enough to raise it to be considered a computer fraud in some way. So it remains to be seen what's going to happen. I'm looking very closely at this case. A lot of people are looking closely at this case because a lot of companies don't want other companies to do data scraping. Also, this will have an impact on some of the Clearview AI cases about data scraping without the consent of individuals. That's it. Thank you.